Imagine this. Your company lands $1 million deal with a foreign distributor. Champagne is popped, contracts are signed, but 6 months later, the distributor disappears, payments stop, and you're left chasing your money across oceans with no clue which court has jurisdiction or whether the contract is even enforceable. This is not rare. This is Florida. I'm Santiago Cueto, a board-certified international business law expert and best-selling author based right here in Miami. I've represented companies from startups to Fortune 100 giants who learned the hard way that international contracts are filled with legal traps, especially in a state as globally connected as Florida. Today, I'll break down the biggest pitfalls lurking in international business contracts and how to sidestep them before they sink your deal. Here's mistake number 1. Weak dispute resolution clauses. The biggest mistake I see, contracts that say, in case of dispute, the parties agree to resolve it amicably. That's not a clause, that's a disaster waiting to happen. Here's the power move. Always include a detailed choice of law, venue, dispute resolution clause, and make sure it's enforceable under both U.S. and foreign law. For Florida-based companies, specifying Florida law and local courts or international arbitration in Miami can save you years in litigation chaos. Here's mistake number 2, ignoring foreign enforcement realities. A judgment in Florida doesn't always mean victory. Can you enforce it in Brazil, China, India? Many businesses win in U.S. courts only to find that the judgment is useless overseas. Why? Because the foreign country may not recognize it, or worse, the contract wasn't compliant with the country's law to begin with. But here's the power move. Before signing, run a local enforceability check in the foreign party's jurisdiction. And when possible, consider international arbitration under rules like the ICC or ICDR, which enjoy better global enforceability. Here's mistake number 3, cross-border payment and currency risks. Here's another classic setup. The contract requires payment in US dollars, but what happens when the foreign government restricts capital outflow or the currency crashes? You'd be surprised how many deals unravel due to currency fluctuations, blocked transfers, or foreign exchange control laws. Here's the power move. Use a payment security structure, such as a standby letter of credit, escrow accounts, or payment milestones with hard currency protections. Avoid open credit unless you trust the party deeply. Here's mistake number 4, undefined performance standards. In domestic deals, vague terms like best efforts or timely delivery are risky. In international deals, they're fatal. Different cultures interpret obligations differently. In the US, timely might mean 30 days. In another country, it can mean eventually. But here's the power move. Define everything. Delivery dates, quality standards, inspection rights, remedies for delay. Be painfully specific, because ambiguity is the enemy of enforcement. Mistake number 5, failing to comply with U.S. export and sanctions law. Even if your international partner is legit, you may be violating U.S. law if the product, service, or technology you're selling falls under export controls, or if the counterparty is on a sanctions list. Yes, even marketing software can get you in trouble with OFAC or the BIS. But here's the power move. Run an export compliance check before shipping or signing. Florida companies especially must be aware. Miami is a hub for Latin American trade, which makes it a hotspot for regulatory scrutiny. Here's mistake number 6, choosing the wrong type of contract entity. You may think signing with ABC Import and Export is safe, but what if that's a shell company with no assets? I've seen this happen dozens of times. When something goes wrong, the real party behind the curtain vanishes and you're left with no recourse. But here's the power move. Demand clarity. Who's the real party? Are they backed by a parent company? Insist on personal guarantees or corporate guarantees when dealing with small or undercapitalized entities abroad. And here's mistake number 7, over-reliance on templates or AI drafting tools. Chatbots and templates won't save you from a cross-border contract disaster. Many Florida businesses mistakenly pull templates from US-only deals and apply them to foreign transactions. But here's the power move. Cross-border contracts require custom legal strategies. Use counsel familiar with both Florida law and the foreign party's legal framework. The cost of prevention is nothing compared to the cost of litigation. Florida is a global business hub. That means incredible opportunity, but also legal minefields. A single missed clause can cost you millions. An international business, what you don't know will hurt you. So if you're doing cross-border business from Florida, don't go in blind. Build legal protections into every contract you sign, because the only thing worse than losing a deal is winning the wrong one. Like, subscribe, and comment if you found this helpful, or if you've ever dealt with a tricky international contract. I'll be sharing more real-world insights and strategies to keep your business protected and profitable.